The 12 presumptions of law: God's law, natural common law, v. Roman law, private legal process. Thou shalt have no other gods before me. Thou shalt not make unto thee any graven image. Thou shalt not take the name of the Lord thy God in vain. Remember the Sabbath day, to keep it holy. Honour thy father and thy mother. Thou shalt not kill. Thou shalt not commit adultery. Thou shalt not steal. Thou shalt not bear false witness against thy neighbour. Thou shalt not covet thy neighbour's wife. Thou shalt not covet thy neighbour's goods. A Roman court does not operate according to any true rule of law, but by presumptions of the law. Therefore, if presumptions presented by the private bar guild are not rebutted, they become fact and are therefore presumed to stand as true. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand as true within their jurisdiction being: 1. Public record. The presumption of public record is that any matter brought before a lower Roman court is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is a private bar guild business matter. Unless openly rebuked and rejected by stating clearly the matter is to be on the public record, the matter remains a private bar guild matter, completely under private bar guild rules. 2. Public service. The presumption of public service is that all the members of the private bar guild, who have all sworn a solemn secret absolute oath to their guild, then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. 3. Public oath. The presumption of public oath is that all members of the private bar guild, acting in the capacity of public officials who have sworn a solemn public oath, remain bound by that oath, and therefore bound to serve honestly, impartially, and fairly as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under their public oath. 4. Immunity. The presumption of immunity is that key members of the private bar guild, in the capacity of public officials, acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith, are immune from personal claims of injury and liability. Unless openly challenged and their oath demanded, the presumption stands that the members of the private bar guild, acting as public trustees, judges, prosecutors, and magistrates, are immune from any personal accountability for their actions. 5. Summons. The presumption of summons is that by custom a summons unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, and witness, and the jurisdiction of the court. Attendance to court is usually by summons, invitation. Unless the summons is rejected and returned, with a copy of the rejection notice filed prior to the hearing or attending, then jurisdiction and position as the accused and the existence of guilt stands. 6. Custody. The presumption of custody is that by custom a summons or warrant for arrest unrebutted stands, and therefore one who attends court is presumed to be a thing in rem, and therefore liable to be detained in custody by custodians. Custodians may only lawfully hold custody of property and things, not flesh and blood soul possessing beings. Unless this presumption is openly challenged by the rejection of the summons and/or at court, the presumption stands you are a thing and property, and therefore lawfully able to be kept in custody by custodians. 7. Court of Guardians. The presumption of Court of Guardians is the presumption that as you may be listed as a resident of a ward of a local government area and are deemed to be under guardian powers of the government and its agents as a court of guardians, unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter, trust before the court, the presumption stands, and you are by default deemed to be a pauper and a lunatic, and therefore must obey the rules of the clerk of guardians, the clerk of a magistrate's court. 8. Court of Trustees. The presumption of the Court of Trustees is that members of the private bar guild presume you accept the office of the trustee as a public servant and government employee just by attending a Roman court. As such, courts are always for public trustees by the rules of the bar guild and the Roman system. Unless this presumption is openly challenged to state you are merely visiting by invitation to clear up the matter and you are not a government employee or public trustee in this instance, the presumption stands and is assumed as one of the most significant reasons to claim jurisdiction, simply because you appeared. 9. Government as executor beneficiary. The presumption of government acting in two roles as executor and beneficiary is that for the matter at hand, the private bar guild appoints the judge magistrate in the capacity of executor, while the prosecutor acts in the capacity of the beneficiary of the trust for the current matter. Unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter, trust, before the court, the presumption stands, and you are by default assumed to be the trustee. Therefore, they deem you must obey the rules of the executor, judge or magistrate. 10. Executor de son tort. The presumption of executor de son tort is the presumption that if the accused does seek to assert their right as executor and beneficiary over their body, mind and soul, they are deemed to be acting as an executor de son tort, or a false executor, challenging the rightful judge as executor. Therefore, the judge-magistrate assumes the role of true executor and has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation, unless this presumption is openly challenged by not only asserting one's position as executor, as well as questioning if the judge or magistrate is seeking to act as executor de son tort. The presumption stands, and a judge or magistrate of the private bar guild may seek the assistance of bailiffs or sheriffs to assert their false claim. 11. Incompetence. The presumption of incompetence is the presumption that you are at least ignorant of the law, therefore incompetent to present yourself and argue properly. Therefore, the judge or magistrate as executor claims the right to have you arrested, detained, fined, or forced into a psychiatric evaluation. Unless this presumption is openly challenged to the fact that you know your position as executor and beneficiary and actively rebuke and object to any contrary presumptions, then it stands by the time of pleading that you are incompetent, and then the judge-magistrate can do what they need to keep you obedient. 12. Guilt. The presumption of guilt is the presumption that as it is presumed to be a private business meeting of the bar guild, you are guilty, whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you either previously prepared an affidavit of status and motion to dismiss with extreme prejudice onto the public record, or call a demurrer, then the presumption is you are guilty, and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. In other words, the whole so-called legal system you know is a money-making scam. It has never been designed to be fair or reasonable. Everyone needs to write and claim standing as true primary executor and sole beneficiary in their legal estates as separate parties, in a fiduciary responsibilities only responsible for the legal estate accounting absolute. DVLA, NHS, Council, Police, Passport Office, Attorney General, and HM Land Registry, and MM Inland Revenue. The name inland tells you it's on the land. I hope you have found this video informative and that it has opened up a new world of possibilities of breaking free from the current status quo, in which so many of us have been hoodwinked into thinking is the natural order of things. If you haven't already, please do like, comment, share, and subscribe to LSB Film Productions for more informative content.